close enough to me. Okay, I'll lean a little more forward. In 1796, Thomas Jefferson said that the Tennessee Constitution was the least imperfect and most Republican of all the documents he had seen to date. It is the duty per that document of the General Assembly to vote without favor, affection, partiality, or prejudice, and not propose or assent to any bill, vote, or resolution which shall appear injurious to the people, or consent to any act or thing whatever that shall have a tendency to lessen or abridge their rights and privileges, as declared by the Constitution of this state. Article 1, Section 26 says, the citizens of this state have a right to keep and bear arms for their common defense, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. Andrew v. State, a Supreme Court case in 1871, used, by the way, to bolster the Heller decision, said this in its majority opinion. The Tennessee Supreme Court has recognized that the General Assembly has the authority under this section of the Constitution to enact legislation to regulate the wearing and carrying of arms in public. Any such enactment, however, must be guided by and restrained to this end and bear some well-defined relation to the prevention of crime, or else it is unauthorized by this clause of the Constitution. The right to keep arms necessarily involves the right to purchase them, to keep them in a state of efficiency for use and provide ammunition suitable for such arms, and to keep them in repair. And clearly for this purpose, a man would have the right to carry them to and from his home, and the legislature has no right to punish him for it without violating this clause of the Constitution. The Second Amendment of our Union says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The amendments are, in fact, a part of our Constitution. Article 6, Section 2 says, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. In Marbury versus Madison, the Supreme Court of the U.S. held, a law repugnant to the Constitution is void. Any act of Congress repugnant to the Constitution cannot become a law. The Constitution supersedes all other laws, and the individual's rights shall be liberally enforced in favor of him, the clearly intended, express, designated beneficiary. In 2010, McDonald v. City of Chicago, the Supreme Court declared the Second Amendment right for individuals to keep and bear arms for self-defense is a fundamental constitutional right under the Due Process Clause of the 14th Amendment, and therefore applies to state and local governments as well as the federal government. It incorporated against the states. In 1821, the General Assembly of Tennessee passed legislation that denied the citizen the right to carry firearms legally, making it a crime to do so. In the recent New York Rifle and Pistol Club v. Bruin case before the Supreme Court last November, the Solicitor General of District of Columbia, Brian Fetcher, in support of the state of New York, held up Tennessee as the poster child for gun control. When he testified, I'm focusing on laws that either prohibited or required a showing of good cause to carry a concealable weapon like a pistol. Tennessee enacted this law in 1821, and it is on their books today. The permits in Tennessee are either exceptions, exemptions, or defenses against prosecution, but the fact remains that bearing a firearm with the intent to go armed is an offense under 39-17-1307. An offense is a crime. Tennessee Supremacy Clause, which I consider it to be, Article 11, Section 16, says the Declaration of Rights hereto prefixed is declared to be a part of the Constitution of this state and shall never be violated in any cause whatsoever. And to guard against transgression of the high powers we have delegated, we hold that everything in the Declaration of Rights contained is accepted out of the general powers of government and shall forever remain inviolate. I ask you today to vote in favor of this bill. It's time that we took the crime aspect off of what is a God-given right to Tennessee citizens. Thank you.
Thank you very much. Thank you for your time and being with us and your comments. Members, do we have any questions for our guest, Leader Lamberth?
Thank you, Mr. Archie. Good to see you again today. And that was a great recitation of kind of the buildup of the laws that we have on the books. But I wanted to get specifically to this bill. And this has been a bill that I know you and I have talked about several different times, and the concept of it I support. I want to get into just the meat of it just a little bit here. So, I mean, in essence, at some point decades ago, some legislature long before we got here decided to say, look, it's a crime to carry a firearm for purposes, to go armed. And then they made several exceptions to that. Now, I do disagree a little bit on how it works in practice, and I know I've talked about this, but, several of us practice in the courts throughout this state. You're not prosecuted and then the exception comes in. The exception's built into the statute, and so it makes it where it is not lawful. Or it is not unlawful, excuse me. It makes it where it is lawful to carry in quite a few areas, just like last year with the constitutional carry bill that expanded significantly those areas. And I want to ask a question about that. So a subdivision in this deletes 3917.13.11. And that's a pretty extensive section. What's the intention in deleting that? And again, not opining whether I agree or disagree, just asking the question on what's the intention of deleting 3917.13.11.
I think it is exactly what we intended when we wrote the bill, was to clean up the aspect of it being a crime in Tennessee to carry a firearm. And so deleting that, we're trying to go through the code section as time after time we come before these committees with a bill that doesn't necessarily clean up all the code sections, so it gets rolled because it doesn't take out everything that is necessary for us to get that issue done. And so deleting that portion is what we're trying to do, is get everything out to where it's just not a crime. And you and I have talked, again, like you said, about in practicality that it's not a crime. However, it says so in 1307, and that's what we're trying to do, is remove that.
Well, I know that, but in 1311, it actually it provides for quite a few defenses in there.
Yes, sir.
And exceptions. I mean, things like, carrying a gun or a knife into a gun or knife show, and there's an exception there, and I'm worried about losing that type of defense, because I don't want someone who's going to a gun or knife show, I mean, most of these are gun or knife shows, to somehow or another trip over a statute or even a local municipality, rule, which I don't think should prohibit those things either. Are you absolutely certain that somewhere else in your bill you're providing for those defenses? Because I don't want a law-abiding gun owner, and I know you don't want either,
I do not,
or a law-abiding knife owner to lose a defense that they have now. It takes out a big section. Are we losing anything by taking that section out of defenses that are available?
If I'm not incorrect, Chairman, if I may respond to that, if I'm not incorrect, I think that no municipality can supersede what the state legislature does. Is that correct?
They're not supposed to.
Okay. That being the case, as I understand it, what we were trying to do in going through the total list of code sections in this is to simply make sure that we remove everything that would be an impediment to a non-criminal carrying a firearm on their person. If you would like to make a motion to strike that portion of our bill, then I am certainly all for that, because I've been working on this, as you well know, for 25 years. And so.
No, and thank you for that. I mean, I'm not making that recommendation or even motion. I'm just asking kind of what was the intent there. And so, but I just want to make sure we're understanding what the intent is. I mean, there are sections of 1311. I mean, it's, and again, I support both your efforts and the sponsors' efforts to clean this up, because it is very difficult to wade through this for anyone, and it should be simple. And I know that's the goal. I just, at some juncture, either today or at another opportunity, I just want to make sure we look at that very carefully, because we're taking out some offenses, we're taking out some exceptions and defenses. I just want to make sure we don't lose anything in the swap. So just a suggestion, and those are my questions for right now, Mr. Chairman.
Thank you very much. Anyone else? Okay. Thank you very much.
Thank you.
For your time.